and welcome back to our Lunch and Learn for a Friday. This is the second in our series about the upcoming changes for indirect collection in New Zealand. And my name's Caroline Carver from Three Black Cats. If you've got any questions as we go along, please feel free to pop them in the Q&A and we will either address them as we go or we can address them at the end for you. Any question in there you ask, you're welcome to ask anonymously, so feel free to use that function. So last week we spoke about what indirect collection was and where it was in your organisations. As we talked about, the amount of indirect collection will vary by organisation, but it's likely to be higher than you would expect it to be. And it will either be coming from other organisations, such as the Credit Bureau, or maybe a company who are providing a reference for somebody, or it could be coming from an individual about another individual. So that's your car insurance claim made by the claimant, telling someone, telling your organisation about who crashed into them, for example. So last week we suggested that you went and had a look and had a think about all your indirect collection and where it was coming from. This week we're going to talk about, now we've identified that indirect collection, what do we need to do about it? So first and foremost, I mentioned last week that the changes are about providing notice for that indirect collection. However, they don't vary the requirement for IPP2, which is to only collect indirectly if there is just cause and one of the exemptions applies. So the first thing absolutely that should be done before we worry at all about how to provide notice is to work out, is this collection actually in accordance with IPP2? Because if it is not, then we need to address that issue well before we deal with how are we going to provide that collection notice for people. Can I just can people hear me okay? Can someone just pop in the chat if they can hear me? Yep, okay. Helena, I think it could be a U setting, but we will have it recorded for people if they are struggling. So let's think about this notice. So we're required to give notice if we have collected information indirectly about individuals. So what does that notice need to take part of? So it needs to be provided at the moment in the current draft, and I have had a check this morning. The third reading is no further progressed in Cabinet than it was last week. But at the moment, it is scheduled for the 1st of May 2026. So if you are collecting information indirectly from the 1st of May 2026, then you have to provide notice to those individuals. In terms of that, one of the key exemptions is if you are collecting information under an approved information sharing agreement that's currently in force, then that will be varied and you won't need to provide that notice. So the requirements are we provide the notice as soon as reasonably possible post-collection if they haven't been told before. So what does post-collection mean? That means once you receive the information from another party, person or organisation, then you need to tell the individual it's about. So in terms of that, that might mean for some of you, it is real time or near real time. In other cases, it might be actually, we're going to write to this person, say it's a referral, right? Hey, we've received your referral and here is your appointment date with us. You can most likely write at that same time, and by the way, we've received your information and here is a copy of our privacy notice. However, that without undue delay, or as soon as reasonably possible, needs to consider both technically what you can do and what cost it is to you, but also what are we trying to achieve with this change of legislation? So we're trying to make sure that people are aware that you have their information and therefore can request a copy or understand how you're going to use it and downstream implications of it. And also that they're aware it's there so that if there is a breach or something, your first communication with them is not, oops, had a moment, sorry, serious harm to you. Right? Sorry. So how are we going to give this notice? Now, how we give that notice will vary depending on your circumstances. You need to give it in a way that fits for that person. So, for example, if you think of your current privacy notices that you are giving, then you would sometimes give them verbally over an IVR when you're making a call recording. Hey, just to be aware, we're collecting your information for training and prosperity, and if you want to see our privacy notice, it's here on our website. That might be appropriate. It might be appropriate to email it to someone or put a link in a communication to them. It might be that you need to post it to them. If you are going to struggle to get hold of them, it might be that you need to make it more publicly available on your website, direct people to it. And that is going to vary depending on each of your circumstances for indirect collection about what is appropriate to get that information out. So what do we need to say? So the legislation as it's currently drafted requires us to say pretty much the same as we would if we collected your information directly. So we have to say we've got your information or we're going to collect it, why we've collected it, so the purposes, who's going to receive it, our name and address, if it's not branded or a link to our website, whether it's optional collection or compulsory, and then the fact people have the right to access it. So from this, you can see that the legislation has been drafted so that you could quite easily use your same privacy statement that you are currently using to also work around indirect collection. However, additional guidance, and it's only in draft at the moment, has come out from the Privacy Commissioner. We'll await the final version of it about what we need to say. And it does go further at the moment in that draft than what is currently expected for a direct collection privacy notice. So, for example, they've indicated the intended recipients must be by name. Okay, so currently we might say in our privacy notice, we intend to share your information with credit bureaus or our affiliate marketing companies, is a common one, or our partners. Under their guidance for the indirect collection notice, they said it needs to be named individuals. So if you think of yourselves as potentially a bank, rather than saying we might share your information with our mortgage advisors who aren't part of the bank, they're an individual company, we would need to say it's Bob and Fred and John's company. Okay. Now, there is going to be a balance that needs to be struck. And I know a lot of you have fed back on that initial guidance about the privacy statement that we're going to give needs to be understandable, practical, and able to be kept current. As we can see, if the list of recipients is by individual company name rather than class of organisation, it's going to be a long list in some people's cases, which is going to be an unreadable. You can to get a given notice is the way people feel they understand how their information is going to be used. So my suggestion would be that you use your current privacy statement that you have and embellish it and add to it. Couple of reasons for suggesting that, and that is about ongoing management. For things like the purpose of collection, a number of you do change what you're collecting information for and why over time. If you have two privacy statements, one for direct collection, one for indirect collection, it will get out of step. It's bound to. It's human nature. They won't line up. The other issue we've got is that if you have someone who you originally collect their information indirectly for, so say they have been a referral and then they become a customer of yours afterwards and you give them a direct privacy statement for direct collection and the two don't match up, there will be questions about which one takes precedence. So much the cleaner is to have one that meets all the requirements for both direct and indirect. Now, for a number of you, that will mean that you are going to need to make changes to your current privacy statement because it might talk about the information we collect directly from you. And it might also talk about how only a subset of the information, so it might not talk about some of the indirect collection because it doesn't require to at the moment. In terms of, John, your question about do we have to name the company or the individuals? We need to name the company or individual it has gone to. So if it's gone to a person who's acting as a sole trader or an individual who's acting in their own right, then it will need to be them. If it is a company, we will need to go a company. The reason I said individuals, a lot of mortgage advisors tend to be sole traders for it. So yeah, just depends on who it is on there. Now, there is a secret to it about how long we need our privacy statements. This is a good opportunity to review your privacy statements anyway. See if we could potentially layer them to make them a bit more readable. Do we need everything in there? Is it actually accurate and current? Or is this a great opportunity to review them? And that comes actually in good timing with the Privacy Commissioner's reminder to people to review their privacy statements or privacy policies, as some people have called them, which is a US term. To ensure that they actually comply with the New Zealand regulations. So a number of people have historically got their privacy statement as a template of Shopify or wherever else you grabbed it from. And it's very US based. It doesn't actually meet the requirements of New Zealand. So definitely a good opportunity to just have that refresh regardless. And get that updated. So if we think about how we're going to go about doing this, we need to think about this transparency piece. So how are we going to be transparent to people without overburdening them, right? They don't want to have a million of these notices. So we need to think about different ways of doing this so that we don't get complacency in terms of updates, etc. from people. So that's where we need to think pragmatically as an organisation about how do we get these out quickest, best, etc. And we'll talk about some challenges of that as we go. So one of the first things that is in the legislation is if we have previously advised an individual, we don't need to give them advice again about our privacy statement. So if we have already, for example, given them a privacy statement because we have collected half their information directly, and then we go and collect some of their information indirectly, that is one of the examples we wouldn't need to give a privacy statement to. So we can possibly, when you get your list of all the collection you're doing indirectly, be able to tick some of those people off. We've already given them a privacy statement. If we are, however, receiving their information from somebody else, and they have been told that we're going to receive their information, then we are not required to give them notice. However, the obligation remains on your organisation, the receiver, to be comfortable that they have been given that notice. So you have to have a sound basis for believing they've given it, not just they said so, but actually we've checked their business process. Maybe we wrote it into their contract as part of disclosing to us that you have to have that notice provided. Maybe we signed off on the wording of it. Also, OPC's current draft of the guidance says that we need to have evidence that the actual individual was made aware. So that goes one step further than it being made available. So, for example, if we take our credit bureau, it is not enough for the credit bureau to say in their privacy statement, we will disclose it to all these people who are part of our credit bureau, and expect that all of our customers have read it. Okay. We know loads of people have never read the privacy statement, even if it's collected directly, never mind indirectly. Okay, so we need to have evidence that they actually are aware of that. So that might be, for example, a tick box. When they have collected information at the credit bureau, it says, tick, I understand it's going to go to party A. Okay, or I understand by providing this information as part of a referral, it will be sent to the hospital that I want a referral at. Yeah, no surprise here. And at that point, they're given maybe a link to your privacy statement where they can go and read more information, etc. Now, again, about management, we don't want those third parties who are providing information to all have a copy of your privacy statement everywhere. It comes back to that management piece. If they've all got a copy and you need to update it, you're going to have to work with every one of those third parties who's providing you that information to get it updated. It's going to turn into your world's biggest nightmare really quickly. So most probably in those indirect ones where they are giving notice on your behalf, you're going to want to be giving a link to your central privacy statement or notice that you've got on your website about indirect collection and what's happening, so that people can read it, but it all stays in step with each other. Now, we're going to talk a lot more next week about what this means in terms of contracts and why we might want to make changes to the contract. So we will wait for next week to talk about that one a bit more. But as I say, just to reiterate, the responsibility for providing the notice and the accountability for it remains with the receiving organisation. So if you are having that information provided by someone else to you and you're going to rely on this exemption, then you need to be very sure about your third party who's providing it, and you are still on the hook if they don't do it. Okay. So what are some of the other exemptions? So first one, it would prejudice the rights of the individual if it wouldn't prejudice the rights of the individual if we didn't tell them. Now, this sort of sounds counter, right? Because we're saying we made this legislative change so that we make it transparent to people. And then we say, well, one of the exemptions is if it won't matter, then it's okay for us not to provide this notice. So therefore, we need to be very, very careful when we use this exemption. It is really going to be for very low risk, low sensitivity personal information that we're going to use this exemption. And it comes down to that running a no surprises test. So for example, if an individual would be surprised later on that you had their information and was using it in this way, and might be like, ew, that's kind of icky and I don't like it. Most probably this is not the exemption for you. Okay, so this is the exemption that we might use, for example, when you ask your employee to tell us, who would you like us to contact in an emergency if you become incapacitated at work? And they say, I'd like you to contact my partner. Here is their name. Here is their phone number. Okay. There is no reason you couldn't provide their partner a privacy statement at that time. However, most probably the collection of solely their name and phone number on a one person basis is probably not going to put them at great risk. To be honest, they most likely have an expectation you already have it as well, and want you to have it. Okay, absolutely, they could request a copy. They're going to get the name and their phone number back. Okay, so it's used for those sorts of scenarios where the information we've got is very, very minimal, and there is an expectation we most probably already have it. Okay. However, it is most probably going to prejudice someone's rights if, for example, we gave it to a parent company. Maybe we're part of a group, we gave it to a parent company, and they're going to use the information to market to you or to build their database, right? That is going to prejudice the rights of that individual. They may not want it, they may want to opt out, and they are certainly not expecting it. Okay, so that's definitely one of those ones where we wouldn't be able to use that exemption. Some of the other ones we have, what if it prejudices the collection? So this is actually a really common one, right? If we're doing a fraud investigation, and we've received a tip-off about you, I don't know, somebody's called in and we've said we're fly tipping in the local council and it was Bob down the road. Most probably at this point, even if we've got photos of Bob doing it, etc., we're not going to want to write to Bob and say, hey Bob, local council here, just so you know, we've got your information, and we're going to use it. And one of the reasons we're going to use it is to take action against you. Okay, most probably not going to work for us, going to prejudice our investigation, something rotten. Okay, so in that case, then absolutely we do not need to give notice at the time of collection. However, a couple of things to consider here. First and foremost, are we actually using the information? Because if we are getting a ton of tip-offs and we are doing nothing about it, then it's not going to prejudice our investigation because we're not doing an investigation. So that exemption wouldn't apply. So just think about all those feeds that you have into you of sort of tip-off, fraud investigations, etc. Considering, are you actually using the information when you've got it on your register of indirect collection? Currently, the draft guidance from the Privacy Commissioner also states that once this exemption no longer applies, that we need to give notice at a later date. So, for example, we're not going to write to our fly tipper at the point where we get his information. However, once we've done the investigation and we've confirmed that it was him and we've sent him an abatement notice, then absolutely at that point we should give him a privacy notice too. Okay. Now OPC's guidance on that is that it needs to be given. There has been a lot of feedback on that for a couple of reasons, with the main one being, how do you manage and know when that tip-off risk has been reduced down and when should you give that privacy statement? So this is definitely an area, if you are collecting due to investigations, just to keep an eye on and be aware of what is happening here. I am really hopeful that is going to change, and it will be that if the exemption applies, that we don't need to provide it ongoingly. However, for transparency reasons, if we are going to keep hold of that information after the investigation, there are definitely some transparency benefits to telling people, regardless of whether it's the legislation or not. So, next one we have, it's not practical to tell people. Okay, now I'm expecting a whole bunch of us are going to try and see if we can justify it's not practical. It needs to be kept in proportion. So the more sensitive the information, so say it's been a health referral, right? The level of practical would be a lot higher than it has been someone's name and address to get the lawn mowed provided by a rental company. Okay, the sensitivity of those two is wildly different. Okay, so we need to keep that in consideration when we think about what is practical. We also need to think about what size organisation are we, how much money do we have, etc., as to what is practical. So the expectations, for example, of a bank versus a small charity on what is practical are going to be quite different. We also need to consider, though, why this legislative change was made. And this was about increasing transparency. So if we're the organisation who goes, well, you know, we have got your information, but it wasn't practical to tell you, it's not going to build that trust and confidence in your organisation. It's also not going to work well for you if you do have a breach later on and you have to write to these people, because it'll be your first engagement with them. Whereas if you've given a privacy statement before, then at least they were aware that you and them had some form of relationship with each other. That said, there are times when it is not practical to tell people. The most common one, we have no idea who you are and we have no idea how to contact you. Right, so if we take an example where we are told that, take a car crash, right? The car crashed into me. I didn't get the number plate. The lady was in red. She's about 40. Oh, could be half in New Zealand. We are never going to be able to contact them because we just don't know who they are. Okay. But a lot of our indirect collection, we do have their contact details. We have their name, we have their phone number, we have their email address, etc. Because actually we need it for our business process. So for example, if we think about joint accounts where I open an account and I decide that I want to add John to it as someone who can act on my behalf, I ring up, I say, please add John. Here's his name, here's his phone number, here's his email address. There is zero reason you cannot write to John and say, hey, John, Karen's added you to her account with us. Here's our privacy statement, just in case you call us ever or tell us anything further. Okay. So be very cautious of how you use this exemption and how long it's going to get there. Some other exemptions, some slightly odder ones. If it will compromise someone else, okay? So if us telling the individual we have received their information will disclose a trade secret, now it needs to be a proper trade secret, then we don't need to provide notice. Equally, if it will prejudice the commercial position of the person who provided it to us. So, for example, we're looking to sell our business. We have provided all of our HR information to another company who's going to buy it. That would absolutely prejudice our position as the seller of that company if they wrote to all our staff and went, hey up, we're thinking of buying your company. Just hey up, here's a privacy notice. However, there is no exemption if it will prejudice the commercial position of the receiving organisation. So if you are the Google data lake, where you prefer people didn't know you had all their information, it would absolutely need to be given. The fact that it would prejudice your commercial position is not a reason not to do it. Okay. So we just need to think about how that one works and be very cautious as we work through that exemption. We have a few other exemptions. Common ones, maintenance of the law. Now, that maintenance of the law is a law in the public sector. So a lot of public sector might be able to claim maintenance of the law exemptions, or actually it's going to be of public revenue benefits, etc. They might be able to claim under that one. Other ones we get, information is publicly available. I would really recommend, if you think you are going to use this exemption, to have a look at the guidance the Privacy Commissioner has given about what publicly available means. It doesn't mean what everyone naturally thinks, oh, it's on the web, it's publicly available. So I saw it on Facebook, therefore it's publicly available. That is not publicly available information. I've had to create an account in order to be able to see it on Facebook. Okay, so if you are that organization who is creating your marketing list by seeing who's engaging with your ads on Facebook, or even worse, your competitors' ads, and then collecting that information, that is not publicly available. So I probably need to think about that one a bit more. Other things, it might provide or pose a serious threat to health and safety if we tell people we have received it. Now, that's a threat to the health and safety either of the individual who the information's about, or to the person who provided it, or to your organisation. Okay, so there are some people, for example, if we were a domestic violence organisation, charity, for example, when most probably and a victim of domestic violence is telling us about their circumstances with their ex, it is not going to be sensible for us to write to their ex to give them a privacy notice and tell them that their ex-partner is working with us, has told us all about them. It's going to put their partner in threat of harm. It's most probably going to put our own staff at threat of harm as well. Okay, so just think about from all those different angles what it might be useful. Other exceptions we have, we're going to use the information in an anonymized form, or we're going to use it for statistical or research purposes. So this is particularly some of our research institutes, maybe Stats New Zealand, Earth and Science, I think it's Earth and Science New Zealand now, what was NIWA, who are collecting information from other parties, so maybe from local councils, MPI, etc., and they're using it to do research for the greater good of New Zealand. Right, they are not going to write, or do not have to, they could choose to, but they do not have to write to you and say, hey, Stats New Zealand here, by the way, we received your information from MSD as part of inclusion in the IDI, the stats interchange. Okay, they don't need to do that. Other places we don't need to do it is archival for the general public interest. So this is about museums, public libraries, etc. If you are receiving the information so that you can archive it for the general public interest, and it is actually of general public interest, is the first hurdle, then you don't need to contact them to provide that notice. Okay. So thinking about whether it's actually the general public interest is your first hurdle on that one. And then the last things we have is around security and defence of New Zealand and its territories. Unless you are a law enforcement agency or a border protection agency, really unlikely you're going to be needing that exemption. Okay. And if you are, get legal advice, because I really don't think it's likely, should we say. So, where to next on all of this? Need to think about what we're collecting indirectly, and then we need to go through and have a look and go, should we be collecting it first and foremost? If no, find a new process, don't collect it. Check your compliance with IPP2. If yes, then we need to think about, do we need to give notice? And that's when we then need to work through, does one of these exemptions apply? How are we going to get that notice to individuals, etc.? We might need to, at that point, think about updating our privacy notice and thinking about how we design our business processes so that it gets given to those indirect collection. So if you think about that business process I was talking about where I add John onto my account, maybe the process when I hit save is we go, do we already have John in our database? Yes, we do. Cool. We don't need to provide him another notice. No, we don't. Okay, we need to send a notice at this point to John. Oh, we've got an email address for him. Cool. We'll send him an email saying you've been added to Caroline's account. And by the way, here's a link to our privacy notice should you wish to read it. Okay. And then keep an eye on the Privacy Commissioner's guidance. Hopefully it's not far away, because we might need to think about that process for identifying when the exemptions no longer apply and how to give notice. So that's particularly those law enforcement ones where once the investigation is closed, how might we need to give notice for those ones? I would hold off on doing much work on that changes those processes until we get that final guidance from the Privacy Commissioner, because I do have a feeling that is going to change on a very practical level on it. Perfect. So that is all we have. I'm going to talk about this week, and we'll turn over to some of our questions. So